I think that Gerald Rosenberg's The Hollow Hope is a good example of a book that's made a big splash, drawn lots of attention, which I think calls attention to its relevance. I think that the book did all of us something of a service by questioning, I think, assumptions that are deeply rooted in our culture, certainly in our legal culture, about the efficacy and the impact of courts, and in particular the U.S. Supreme Court. What the book does is question whether landmark decisions really had the transformative impact that many people have alleged, or at least many more people probably assume. As somebody who grew up in the 1950s and 1960s, certainly as a young person, I thought of the court as a major engine of social change, for better or worse. And it took me a long time to really come to interrogate that assumption, and Jerry Rosenberg did us all a service in that regard. I don't think that's the end of the question. I think that the real service is that it opens up a whole variety of other more interesting questions, or not necessarily more interesting, but different kinds of questions about the role of courts, how court decisions, and in particular how litigation, the process of litigation, figures into struggles for changing social policy and changing social relations. I think that Jerry Rosenberg chose a very interesting research design to try and build his case. One of the very strong premises that's important to understand in considering what it was he did is he began with the court as an agent. His question is really, can courts change the world? And so that the justices on the Supreme Court, or if applied to other courts, judges, they become the agents. And the question is, when they act, or how often are they likely to act? And one of his arguments is that courts tend to be relatively conservative because of the bounds of and the bonds of legal precedent and the constraints that the courts face in a variety of ways, and because courts do not have the kinds of resources that legislatures or executive branch has in terms of controlling money or controlling police and enforcement powers and so forth. That courts tend to be very cautious and conservative, and that when they do act, they don't have the capacity to implement what they did. So he makes them the actors. And his methodology is to begin with landmark decisions that many people have assumed had great transformative impact, like Brown versus Board of Education or Roe versus Wade. And then he has chapters on environmental litigation and so forth. And to begin with those decisions and say, what happened? And he looks for causal impacts. He said, was there a change in bureaucratic behavior? And it's mostly a very compliance-oriented kind of standard. Did others change their practices or behaviors or policies in compliance with or conformity with what the courts ruled? And so the standard for him is what the judges said, or justices of the Supreme Court, what they said, and did that translate immediately into that kind of action? And so, and his logic is to draw a causal arrow, action, reaction, or response. And if they line up so that there is one that one can feel confident about, the action produced the reaction, he shows that there's significant change. If there's not such a change, or if there are intervening factors that seem to produce a change, that would question whether the courts were really a major player or had a major transformative impact. That's one way of studying whether courts matter or not. But there are a variety of other approaches to ask those questions as well. One alternative to the Rosenberg approach is not to make the courts the primary actors, because I think many of us would agree that he's right. Can courts as agents of social change make a big difference? And he's right. Courts tend to be quite conservative, especially throughout American history. The period of the 1950s through the 1980s was a relatively unusual period where the court was aligned with what we might call a liberal or progressive kinds of change. That's not been the primary role of the courts. But even during that time, one could argue that what they did was very cautious and largely in conformity with what other branches and other powerful players in American politics wanted. So instead of focusing on courts as the initiators of change and the agents, most of my work is about litigation. Litigation as a process that involves many other kinds of actors and has many other dynamics that don't necessarily turn on the actions of the courts or their capacity to implement and enforce what it is that they do. For example, some work that I have done shows that winning in court is not necessarily the most important way to use litigation. Often losing in court can be very useful. It can dramatize a social problem, generate a lot of media attention, and then provide an incentive or a catalyst for other actors to take up the cause, whether it's a legislature or so forth. And when that happens, that's actually more effective because legislatures do have the tools of enforcement, particularly through control over money and so forth, to make for effective kind of change. Many times when people file lawsuits, those suits often don't go to trial, don't go to a final judgment, whether it's at the appellate level of the Supreme Court or whether it's at a lower court. But in the process of filing litigation, that can add significant, what I call leveraging power to advocates for particular kinds of changes. Just filing a lawsuit can get the attention of adversaries or opponents, can dramatize an issue, can mobilize media support under certain conditions, can mobilize other groups to come to follow behind in support of an issue, and that what began as a case of litigation can turn into change again at other levels, legislative levels, or just change in practices quite directly without ever even falling through the lawsuit. But the key to that is to focus on litigation, those who are advocating change, to interrogate what it is they're trying to do, and to look at the ways in which they use litigation or coordinate litigation with other kinds of political tactics, such as legislative activity, interest group lobbying, social movement activity, media, courting the media for attention, those kinds of things. But by shifting from the courts as agents of change to groups or social agents, which often involve and may feature prominently lawyers, one gets a more dynamic and complex kind of picture about a politics of rights advocacy, or a politics of what I call legal mobilization. Let me give a couple of examples, I think, of the ways in which litigation can figure into significant histories of social change. One is an area of prison reform. There's a terrific book written by Malcolm Feely and Ed Rubin that shows that in the 1970s that a number of judges, federal judges in the U.S., became very concerned about the issue of the conditions in U.S. prisons, and that that recognition paralleled and interacted with, at the same time, the concern about internal reform by a lot of corrections officers and managers of prisons. And there was a parallel movement that became interactive that led to quite dramatic levels of prison reform in the U.S. And that's a great example of courts being initiators of action and working with other players to achieve significant kinds of reform. A second example is a very recent book. I was just talking about it the other day by a scholar named Chuck Epp called Making Rights Real. And it's a terrific book because he looks at the struggle over police accountability and the issue of excessive police force and violence. And what he shows is that one of the primary issues that led to the civil rights movement in the 1930s and 40s was police violence against African Americans in the South. And in the 1950s and 1960s, significant numbers of attorneys began to take that issue up and bring tort-like lawsuits, mostly in local courts, but also in some federal courts. But it's mostly a local issue. And in bringing those lawsuits, what they did was to put on the agenda the issue of police abuse, generated lots of attention, but they also put police chiefs and internal leaders in police departments on the defensive at first, but then began to lead to questioning about, well, maybe there really are issues of police abuse, maybe we need to begin to do something. So they began to professionalize police forces, to increase rule-based training that restricted the use of force, that set out the conditions for the use of force, that trained police officers in how to respect the rights of assumed alleged perpetrators, and to professionalize police department in a very legalized kind of way. And what he shows is those lawsuits are what began that process. But it was the outside activists who began that process and then continued to hold the threat of suing for liability of police departments that abuse citizen rights, along with in concert with the internal desires of reformers to transform police departments from the inside, that those two factors together have led to a dramatic change, not a complete change. We still have problems of excessive police violence, but it's dramatically different by the 1990s and the contemporary period as it was 40 or 50 years ago. I think the different kinds of questions that I raise about how litigation does or does not matter have led me to engage in a different kind of research approach than what Rosenberg uses. It's interesting, the book that I wrote on pay equity, the first paper that I wrote was a very Rosenbergian analysis. I said, why are these people filing lawsuits? Because the courts will never go along with this. And I said, even if they do, it's not going to matter. That was the very first paper I wrote, which is 10 years before Rosenberg published his book. But I abandoned that because at my own university, I ran into somebody who was a leader in the national pay equity movement. And I said, why are you filing lawsuits? That's a waste of time. And she gave me about a 2-hour explanation why litigation was so important to what they're doing, problematic piece of it. And so from that, I began to do more interviews. And she said, she had the archives for many of the struggles over pay equity around the country. So I engaged in a summer-long study of archives for all of these movements, all these local manifestations of the pay equity movement around the country. And from that, I developed a case study approach where I specified 6 case studies that I was going to travel to. I applied for a National Science Foundation grant to support it. And I combined a big end study about all of the cases around the country, or about 50 cases, and then I chose 6 of those to focus on. And I used traditional qualitative methods of archival research, extensive interviews. I interviewed several hundred participants in this, in this politics, and largely told narratives of these stories and from the points of views of the activists themselves. And so as opposed to a big end study from the top down, I engaged in a more bottom-up study, which brought me into contact with the activists themselves. And that's where I first realized that, well, from the outside, litigation may look like a waste of time or an unproductive strategy, but from the inside, it looked very, very different. And much of my work has been trying to understand the world from in which actors act and why they do what they do. And it's not to accept that, but is to engage critically with their own understanding from what we know from social science, to kind of put it to the test of social science. Another question that arises from this also is that sometimes courts have big impacts, but those impacts are really full of unintended consequences, which in fact are not as positive as people who may have celebrated an actual victory in court. And let me give an example from Brown versus Board of Education, which is one of the key examples in the Rosenberg book. Many people would disagree with Rosenberg that Brown did not have significant impact. If one says, did the court change American society in a short period of time? He's absolutely right. But would raise the question that Brown was a critical moment in a developing political process. And if Brown would not have taken place, if the court not articulated Brown, that a series of subsequent events and transformations probably wouldn't have happened, although we can't ever know that for sure. But it's one thing to say that the court didn't have impact, and it is to really look at the complexity of the impact that it had. And the problem with looking at what the courts say or judges say is a standard of assessment misses the larger question about what is it that the larger movement behind the litigation is really after. And what historians have taught us is, by studies in the 1930s and 1940s, that the major issues that concerned the African American community in the 1930s and 40s was not school desegregation, but were issues about excessive police violence and lynching, issues of lack of access to good jobs and good paying jobs, and access to capital for loans for buying homes or starting small business. Those were the primary issues. And there was lots of activism around that. And at that time, school desegregation was not a major issue. For a variety of reasons, the school desegregation issue is the one that made headway in court. And a variety of issues that were related to economic prosperity, equal opportunity in schools became a logic. But again, it was a secondary part of the agenda. But that's what the courts chose to in early cases before Brown, begin to give signals they were willing to hear, to listen to, and there was begin chipping away at that edifice of segregation. So then Brown articulated the issue of civil rights as one of school desegregation. It shifted what had been a movement for a variety of other rights claims and other kinds of reforms to the entire game now was around desegregation. And this desegregation model became what civil rights was about, as opposed to issues that involved jobs and access to capital and police violence, although some of those issues continued to take on. But much of the 1960s politics of African Americans who were disappointed by Brown was not just that Brown hadn't changed the world, but that those earlier agendas that mattered so much to the African American community had been displaced or marginalized or lost momentum because Brown kind of redefined the agenda. And it's not to say that school desegregation was not an important issue and that desegregating schools had positive impacts, but it's one of those unintended consequences that the shift from economic rights and to other rights that arguably are quite fundamental were lost in the shifting agendas to entirely focus on schools. It's not surprisingly, in the second half of the 20th century, we think about the civil rights movement and school desegregation hand in hand. That was a curious twist of history and has a lot to do with how the Supreme Court implicitly invited cases and ruled in Brown versus Board of Education. My path into the profession of political science was a long story of backward steps rather than intentionality. I grew up in South Florida in the 1950s and 1960s in the midst of desegregation, and was caught in my time in grade school and junior high school dealing with a whole set of issues about a world that had changed very dramatically the first years of desegregation. And I became very involved in my own schools in dealing with a lot of the complexities that were raised around race relations, and became very instrumental in working with students of color and others to try and make a very difficult situation work out. And that raised a series of questions for me about the changes that were going on. How do big changes in society take place? How are they received? What are the politics behind them? And I continued those interests and became more and more politically active through my teen years. I was involved in labor politics, and I was involved in anti-war politics in my high school, and very involved in politics in school. Carried that interest on as an undergraduate. I studied political science and philosophy and literature and a variety of issues, had several majors. And I was not really ever thinking about becoming a professor of political science. But I was interested in politics, and I was engaged in politics, and I thought my wife wanted to move out of the South into the West Coast and learn about politics. Maybe I would be more effective or have a better idea about what I was doing by studying politics, but it was really never intending to even complete a PhD program or become a professor. But once I went to graduate school, I probably became more challenged intellectually than I had ever been in my, I think, schooling career. And I stayed on, completed my PhD, took a faculty job. I was still uncertain, even with my first faculty job, whether I would continue to do that. I always wanted to be a labor organizer. But I found the challenges and the work of being a professor to be very exciting, and I found that I could stay active in politics and be a professor, and I came to learn that I love teaching, which is something that I never had thought about very much and had never really imagined, but seemed to be something of a calling. So research and teaching was something I never dreamed of doing when I was young, but once I started doing it, I said, this is where I belong.